what's changed is, the primary thing that's changed is two things. One, it had always, historically, an organization cannot be held responsible for the bad things its members do unless it is shown that the organization as an organization has either sanctioned, encouraged, sanctioned, or ratified the bad things that its members have done. And just historically, going back to the 1700s, 1800s, I mean, the court decisions, the state court decisions held that labor organizations are perfectly legal entities. They can do anything you can do as an labor organization. Anything that an individual can do legally, a labor organization, an association of individuals can do, just so long as it's legal. And in order to find that the labor organization had, or any organization, could be the Boy Scouts or Girl Scouts, you know, I mean, has done something wrong, you have to show, if you're going to attribute what the members are doing to the organization, you have to show that the organization has either encouraged it, sanctioned it, or subsequently ratified it, adopted as its own what the members have done. And absent that showing, the organization, you cannot punish the organization for what its members have done. Well, what the new law does is it says, forget all that. Even if the labor organization has done everything in its power to meet the requirements of the law, if any of its members do something bad, the organization is responsible. Period. Now you have to wonder.
And by the new law, you mean Act 10?
Act 10. How does that? I wonder. And the thought that crosses my mind with respect to that is, if, like corporations, labor organizations are human beings or are persons, and persons are entitled to due process of law, how does a statute, a change like that, does that meet the requirements of due process of law, where you can be held as a person responsible for what somebody else has done, even though you haven't done anything wrong at all? I think could be a question there. The other thing that the law does is, it, instead of simply imposing this $2 a day, I think I might have mentioned this earlier, $2 a day fine on the individual who participates in a legal strike, under Act 10, the governor can announce an emergency, or pronounce an emergency exists, which, with respect to a particular labor relationship, and anybody who does not report to work within 3 days after that pronouncement can be fired. Not just pay a $2 fine, but be fired.
Or for any 3 days. Any 3 days during the period of the entire emergency.
Yeah.
So here, and here.
Right. Okay, you're right. So
and the emergency would be like a generalized state of emergency, or just for that sector, or for...
Well, my understanding is, and Katie, you've looked at it more closely than I have, but my understanding would be that what would happen is the governor would say, in the city of Fenimore there's an emergency, and that would then trigger this potential penalty. It wouldn't be statewide. I mean, it's aimed at striking.
Right.
It strikes. So I mean, I'm assuming, since it's aimed at punishing people who strike, therefore it can be aimed specifically at wherever the strike is.